I'm Chris Schrager. I'm helping direct the public law program, and it's a pleasure to have you all here today. This is an event largely organized and executed by the Women's Law Student Association, and the public law program is delighted to co-sponsor it. And Christy Bowman is going to introduce our speaker today.
We won't have too long of a strain of people introducing other people who introduce other people today, but it is my distinct pleasure to introduce Professor Sally Goldfarb. She's had a range of really amazing experiences, and when I think of the sort of career I would like to have in a lot of ways, it really follows along with the lines that she's followed. She's worked at the National Women's Law Center, spent several years working for the now Legal Defense and Education Fund in New York, and all throughout has been a staunch advocate of women's rights and women's issues, especially with attention to violence against women. And she's had a lot of involvement in the enactment of the Violence Against Women Act and in subsequent issues regarding that specific act. Now she's an associate professor, or associate, I always get those confused, at the University of Rutgers in Camden, New Jersey. And she teaches family law, torts, and professional responsibility. And with that, I will introduce Professor Goldfarb.
Thank you, Christy. Thank you to Christy and to Professor Schrager and to all of you for having me here today. In the past 10 years, the Violence Against Women Act has gone from being an idea to a bill, to a law, and now to the target of a major constitutional challenge that's currently pending in the United States Supreme Court. Today I'd like to share with you some observations on this odyssey. Along the way, I hope to consider how the Violence Against Women Act got to where it is today, where it's likely to go from here, and what are some of the broader lessons that we can draw from its journey. As many of you probably know, the Violence Against Women Act is the most ambitious federal response that's ever been offered to the epidemic of rape, domestic violence, and other types of violent crime against women that has long plagued this country. It contains dozens of provisions designed to prevent and redress violence against women, but most significantly, it declares for the first time that crimes of violence motivated by the victim's gender are a federal civil rights violation. The statute creates a new remedy that permits the victim of a gender-motivated violent crime to bring a civil suit seeking compensatory and punitive damages, injunctive and declaratory relief, and attorney's fees. And the victim is not required to first press criminal charges in order to pursue this civil rights claim. Well, this new cause of action is really nothing short of revolutionary. For the first time, federal law recognizes a civil right to be free from violence inflicted on the victim because of her membership in a group defined by her gender. And this whole approach is dramatically different from the usual tort and criminal law remedies, which treat acts of rape and domestic violence as isolated individual events rather than as part of a social pattern. So the Violence Against Women Act reflects the insights of feminism into the pervasiveness of violence in women's lives and its role in maintaining women's disadvantaged social status. It's consistent also with the long-standing legal recognition that violence based on a victim's membership in a disadvantaged group has uniquely damaging effects. Discriminatory violence, first of all, is particularly harmful to its victims because they suffer not only the physical and emotional injury of the crime itself, but also the added psychic injury of knowing that they were victimized because of their group identity. Second, group-based violence serves a terroristic function. It intimidates not only the individual who's been attacked, but all other members of the same group who fear that they could be next. And finally, group-based violence serves the broader function of reinforcing the prevailing subordination of the targeted group, and in this way, violence motivated by gender is an instrument of social control. Now, of course, the law is not accustomed to thinking of violence against women in this way. We don't normally think of domestic violence as a bias crime in the same category as, say, a lynching. And actually, quite to the contrary, a man who beats his wife in the privacy of their own home is usually regarded as committing a very private, personal, individual act. But we need to remember that batterers often use physical violence to express and enforce their views of male power and female subordination. So a batterer might say, for example, I didn't beat my wife or my girlfriend because she's female, but because she burned the toast, or she didn't keep the kids quiet when my friends were visiting, or she dared to go out and get a job when I told her she couldn't. But all of those rationales are directly tied to the most stereotypical and most limiting preconceptions about women's proper role. So during the 4 years when the Violence Against Women Act was pending in Congress, those of us who were supporting its passage repeatedly emphasized that women's vulnerability to gender-based violence results in a kind of second-class citizenship. Just as we can't achieve racial violence, just as we can't achieve racial equality until we stamp out racially motivated violence, so too gender equality is not achievable unless we address gender-motivated violence. And in fact, protection from group-based violence is a precondition for enjoying many other civil rights. So for example, women are offered equality under the law in the workplace, the schools, the community, but that is really meaningless if their safety and their lives are at risk when they try to pursue those opportunities. Federal civil rights law seemed like a uniquely appropriate response to this problem, since unlike other kinds of civil and criminal remedies, federal anti-discrimination measures vindicate the victims' and society's interest in social equality. Now, of course, I recognize that not all crimes by men against women are discriminatory, just as not all interracial crimes are discriminatory. And the way the civil rights provision in VAWA is drafted is to create a cause of action only for crimes of violence motivated by gender. And in order to prove that, the plaintiff has to show that the act was committed because of gender or on the basis of gender, and due at least in part to an animus based on the victim's gender. So for example, a burglary or car theft in which the victim happened to be female would not qualify. During the 5.5 years since VAWA was passed, a number of cases have been brought in which federal judges have found evidence of the requisite gender motivation. They have looked, for example, at the defendant's use of gender-specific epithets during an attack, attacks on multiple female victims, attempts by the defendant to use violence explicitly to force the victim to comply with traditional female gender roles. Those are all types of proof that courts have looked to find that the gender animus has in fact been proven. And the acts of violence in the cases that have been brought to date are quite varied. They include rape, sexual assault, child sexual abuse by clergy, domestic violence, sexual harassment in schools and workplaces, and murder. Well, let me say a word about the process by which the Violence Against Women Act came to be enacted. It was a very controversial bill, and the civil rights provision was the most controversial section of it. It was introduced in 1990 and took over 4 years to pass. There were many times when I thought that VAWA would not pass, or if it did, that the civil rights provision would be dropped from it, since after all that was the most radical section of the bill. Ultimately, after a great deal of effort by people working within Congress, as well as those of us who were lobbying from outside Congress, it was signed into law as part of the crime bill in 1994 by President Clinton. Well, why did it pass? Often people look at how radical the particularly civil rights provision is and say, how in heaven's name did the United States Congress sign off on this? And there are a number of explanations. The first has to be that Senator Joseph Biden was remarkably persistent and committed in his support of this legislation. Many times that he could have backed off from it, or certainly backed off from the civil rights portion. No one could have blamed him. It was really a political uphill battle, but he stuck with it all the way. It was also a bipartisan effort, which was crucial. Senator Orrin Hatch became a lead co-sponsor partway through the effort, and this was in part because compromises were struck on the bill language to bring Senator Hatch on board. You might remember a certain event in October of 1991, the Anita Hill Clarence Thomas hearings, followed by the 1992 elections, the so-called Year of the Woman, when a lot of male members of Congress were voted out, and women throughout the country were saying, you just don't get it. So by the 1993, 1994, the men in Congress were looking very hard to show that they could meet women's needs and follow an agenda that would be meaningful to women. And of course, we did have women in crucial positions of power who supported this legislation, which was enormously helpful. In Congress, Pat Schroeder, Connie Morello, Louise Slaughter, and other women were very supportive. The National Association of Women Judges supported this legislation in contrast to the mainstream judicial organizations, as I'll describe further in a minute. And finally, we did have a very active lobbying coalition, which I founded when I first was contacted by Senator Biden's Judiciary Committee staff and asked to take a look at this proposed legislation. I was immediately very enthusiastic about it, and I cobbled together a mailing list of a few domestic violence and rape crisis groups that I knew of and convened a meeting of what would later become a coalition comprising over 1,000 groups and individuals throughout the country, not all of whom came to meetings in New York and Washington, but they worked at the grassroots level to try to achieve passage of this law. Those are some of the things that helped the law pass. There were also obstacles in its way, and most particularly the biggest obstacle was the judiciary. Very early on, Chief Justice Rehnquist, on behalf of the federal judiciary, spoke out publicly against this bill, saying that the civil rights provision in particular could flood the federal courts with domestic relations matters, and soon the organizations that represent the state and federal judiciaries passed official resolutions condemning this statute because it would overload the federal courts, bring family law matters into federal court, interfere with state prerogatives on domestic relations matters, including, for example, the right of states to exempt husbands from criminal liability for raping their wives, or to exempt spouses and parents from tort liability. And finally, the judges raised the criticism that this would create a civil rights remedy against private actors, not state actors, and that was seen as unwise. Well, eventually, through a combination of political maneuvering and some compromises in the bill language, the federal judges did drop their opposition and adopted instead a position of neutrality. The result was that the law did pass, although in a narrower form than it had originally been introduced. Well, let me turn now to the subject of the constitutionality of the statute, which is currently, of course, a burning issue. When VAWA was signed into law in 1994, Congress articulated in the text of the statute two constitutional bases for it, the Commerce Clause and Section 5 of the 14th Amendment. And from the vantage point at that moment in time, it seemed that Congress's constitutional authority to pass this legislation was undeniable. It had been almost 60 years since the U.S. Supreme Court had overturned any federal statute that was enacted under the Commerce Clause. We all know what happened next, which is the decision in United States versus Lopez, and that in turn was followed by City of Bernie in the 14th Amendment area, and suddenly a constitutional challenge to VAWA became a very real possibility. It's my view that the civil rights provision can withstand constitutional scrutiny even under these newer cases, but of course we have to wait and see if the Supreme Court agrees with me. To date, there have been 19 cases in which the lower federal courts have considered the constitutionality of VAWA's civil rights provision. 17 of those cases have upheld the statute. One of the two that struck it down is the Brancala case from the Fourth Circuit, which is the case now before the U.S. Supreme Court under the name United States versus Morrison. And I believe many of you are familiar with the case. It was originally brought by Christy Brancala, a young woman who alleges that she was raped within a few weeks after she had arrived at Virginia Tech to start her freshman year, and she brought a lawsuit against her two alleged assailants under, among other causes of action, the civil rights provision of VAWA. The defendants, of course, argued that VAWA was unconstitutional. Both the federal district court and the Fourth Circuit en banc agreed with them, and now, of course, the issue awaits the word of the Supreme Court. Let me briefly address the merits of the constitutional challenge. I'll certainly be happy to discuss that with you further if you wish, beginning with the Commerce Clause. In the Lopez case, the Supreme Court held that Congress can enact legislation under the Commerce Clause if it regulates activities that substantially affect interstate commerce. Well, during the 4 years that VAWA was pending, we amassed a huge legislative record showing that domestic violence, sexual assault, and other forms of violence against women have an enormous effect on women's employment, their productivity in the workforce, their travel, consumer spending, healthcare expenses, and interstate commerce generally. Now that's in marked contrast to the Lopez case, where the Gun-Free School Zones Act was enacted by Congress without any legislative findings at all. And Congress did make specific findings that gender-based violence bars its most likely targets, women, from full participation in the national economy. So as we know from cases like Katzenbach versus McClung and Heart of Atlanta Motel, civil rights legislation that's adopted under the Commerce Clause to respond to discrimination that poses a barrier to participation in the national economy is a legitimate exercise of Congress's authority. And in fact, Professor Cass Sunstein, constitutional scholar from the University of Chicago Law School, stated before Congress that the gender-motivated violence at issue in VAWA provides an even more compelling case for anti-discrimination legislation than the nonviolent discrimination in the McClung and Heart of Atlanta cases. On the 14th Amendment issue, Congress also heard evidence and made findings that the states are routinely denying equal protection of the laws to female victims of domestic violence and sexual assault. I can elaborate on this later if you wish, but both the law as written in many states and as administered by state actors like police, prosecutors, and judges is just rife with gender bias against women who are victims of these types of crimes, and the right of action created in the civil rights provision is designed to remedy that discrimination. It is a private right of action against individuals, individual assailants, but the U.S. Supreme Court has not yet stated that Section 5 of the 14th Amendment does not give Congress the power to legislate against private action. Well, what's our likelihood of winning? Your guess is as good as mine. Most observers predict a close vote and multiple opinions in this case. As you know, Supreme Court litigators spend a lot of time counting votes, so I'm happy to do that with you. We know we won't get Chief Justice Rehnquist or Justices Scalia or Thomas to vote with us on this, and indeed, Chief Justice Rehnquist has been on record since about 1990 as not liking this bill. Justices Ginsburg and Stevens just pretty much clearly are likely to vote in our favor based on their own voting history and their judicial philosophy. That leaves Justices Breyer, Souter, Kennedy, and O'Connor. We have reason to be optimistic about Justices Breyer and Souter, and that leaves Justices Kennedy and O'Connor as swing votes, which is a position that they often occupy. There's a lot of speculation, of course, about how the votes will line up, and I'll be happy to talk with you if you wish about some of the early indications as indicated by their comments during the oral argument. I gather some of you were at the oral argument. In this case, some of you were in Professor Dellinger's class. If anybody was at the oral argument in January, could you raise your hand? Okay, I think some of the students at the school were. Well, what's at stake in this case is, of course, the civil rights remedy, which recognizes these types of crimes not just as an individual misfortune or a personal injury, but as a denial of equality. By the same token, I want to make it clear what's not at stake here. I mentioned earlier that VAWA is a very diverse and comprehensive piece of legislation. Among other things, it makes it a federal crime to cross state lines in order to commit domestic violence or violate a protection order. It requires states to give full faith and credit to protection orders issued in other states. It reforms immigration law to help battered immigrant women. It amends the federal rules of evidence to extend rape shield protections to civil as well as criminal cases. It provides for federal leadership on research and record keeping on violence against women. And last but not least, it furnishes an unprecedented level of federal funding, $1.6 billion over 6 years to police, prosecutors, domestic violence shelters, and others. None of those provisions are at issue in the Supreme Court case. What is at issue is the civil rights provision, but of course, in the view of many of us, that is the conceptual heart of the legislation. Well, I indicated at the beginning that I was going to try to look for a broader message here. To some extent, we need to wait to hear what the Supreme Court has to say before we can do that, but I do have some provisional observations that I'd like to share with you. Several feminist legal scholars, including Robin West, Mary Becker, and Ruth Kolker, have expressed the view that legislation holds more promise than litigation as a way to incorporate feminist goals into the law. Their reasoning is that with litigation, you're stuck with applying the law as it exists, whereas with legislation, you get to write what you think the law should say. I do think there's some truth to this, and that writing legislation to serve feminist goals can be a uniquely creative and effective enterprise. But at the same time, I'm concerned that this rosy view of legislation is something of an oversimplification, because it overlooks some of the important constraints that exist in the legislative process. both the political realities of trying to get a law passed and the fact that the statute that you got passed may end up mired in the litigation process anyway. And VAWA is an object lesson in that process. When you put feminist ideals into practice in the legislative arena, I would say that the moral of the story is your battle is not over when the statute is passed and signed into law. The resistance to legal change is, I think, remarkably persistent. The Fourth Circuit's en banc decision in the Brancala case, which struck down the civil rights provision as unconstitutional, refers repeatedly to the danger of embroiling the federal courts in domestic relations matters. That's exactly the same argument that the federal and state judges were making ultimately unsuccessfully in their effort to defeat this law in Congress. So the argument didn't go away, it just came back in a different context. In fact, I think this lesson is not limited to legislation on feminist issues, but applies equally well to any groundbreaking legislation that attempts to change social attitudes. Any lawyer who is working for social change will tell you that you spend a lot of time trying to safeguard the gains you've already achieved at the same time that you're moving ahead to the next challenge. Furthermore, the short but convoluted history of VAWA illustrates the complex interplay between legislative and litigated advocacy. And that process works both ways. Progressive lawyers craft laws that get shredded in the courts, and then we have to go back to the legislative branch to try to salvage what we can. And of course, we also use courts to overturn or expand or reinterpret statutes that we see as standing in the way of progressive goals. So I'd like to leave you with the thought that to be effective, lawyering on issues of broad public concern needs to encompass, at a minimum, both legislative and litigative strategies. It also often includes advocacy before administrative agencies, public education, community organizing, and so on, but at a minimum, legislation and litigation. And indeed, if the Supreme Court strikes down the Violence Against Women Act's civil rights provision in the case before it this term, then I'm quite certain you'll see feminist advocates returning to Congress to seek a new statute designed to withstand constitutional attack, and so the saga of the Violence Against Women Act will enter yet another chapter. Well, thank you, and I'd be happy to take your questions. Yes?
I would be interested in hearing what hints you have of O'Connor and Kennedy.
Okay, well, there's
And
good
then
news.
secondly,
Yeah.
if I just throw both questions out at once, do you think that in the year 2000 or 2001, if this case goes, from your perspective, the wrong way, there would be that Congress would act again in a way that would clear up the problems?
Okay, let me take your first question first. There was good news and bad news, as is so often the case in life at the oral argument. I thought that Justice O'Connor's questioning seemed to display a strong antipathy to the statute. She seemed very dubious of the constitutionality. One question she asked in various guises to both sides of the lawyers before her took the form of, well, if we approve this statute, wouldn't that permit Congress to enact a national alimony and child support and divorce law? Now, as you know, being a family law scholar, as soon as they start talking about family law, you know you're in a lot of trouble because the federal courts hate family law. By the same token, it's entirely possible that Justice O'Connor was asking those questions in order to give counsel a chance to respond and overcome that argument. That either a concern on her part, or she often, I've been told, asks questions that she knows are on Justice Kennedy's mind, and she wants to give counsel a chance to respond to Justice Kennedy's concerns. On the positive front, I enjoyed an exchange between Justice Kennedy and Michael Rothman, who's the lawyer for Antonio Morrison, and he's with the Center for Individual Rights, a conservative public interest law group in Washington. And Justice Kennedy asked the following question on the issue of Congress's authority here under Section 5 of the 14th Amendment. If you had a state that was routinely ignoring the criminal laws prohibiting assault in cases where the victim was African American, or I guess he probably said black, and was applying those laws vigorously when the person attacked was white, could Congress enact a statute like this? And Michael Rothman, representing Antonio Morrison, said no. Congress could pass a law aimed at correcting the discriminatory practices of the states, but could never pass a law creating a right of action against private actors under Section 5. And Justice Kennedy seemed very uncomfortable with that categorical black and white response, which goes way beyond, I think, what Supreme Court precedent would tend to suggest. The Supreme Court has not, as you know, been clear on whether Section 5 gives Congress authority to legislate against private action. And this kind of extreme position seemed unappealing to Justice Kennedy. So, you know, these little things are just tea leaves. We don't know what they really bespeak, and we'll have to wait and see how it falls out. Your second question about where
Likelihood of
Congress...
legislative comeback.
As Professor Schrager knows, there are so many variables that dictate, you know, whether a given statute does or doesn't get passed at any moment in history in Congress. Certainly, party politics obviously has something to do with it, and when this statute was enacted in '94, the Democrats controlled both houses as well as the White House. If we had conceivably Republican control in both houses plus a Republican in the White House, it might be harder. On the other hand, not necessarily impossible. As I mentioned, it was a bipartisan effort the first time round, and I guess it would depend in large part too on how the statute is drafted and whether it's, you know, perceived as politically appealing to the people who we need to appeal to. Yes.
Your description of how the civil provision incorporates feminist thinking made me wonder whether there's been any success at the state level in convincing legislatures or in judicial creation of a similar cause of action at the state level, or whether this is limited to the exclusive federal.
In the state of Illinois right now, there is a statute modeled on the a bill modeled on the Violence Against Women Act civil rights provision that is currently pending.
Mm-hmm.
And I know that the feminist advocates in Illinois are very excited. They've mounted a big lobbying campaign. From my perspective, the timing was maybe not ideal. We would not necessarily want the Supreme Court to read about that in the New York Times and conclude, well, hey, we can strike down VAWA because every state is going to do their own. That is the only state that I know of that has even considered doing something like this. A small number of states, maybe 6 or 8, have some form of civil remedy for discriminatory acts of violence based on gender, but the form that takes varies. Sometimes you have to go through a state administrative exhaustion process, a civil rights commission or something like that. Obviously, if the United States versus Morrison case strikes down the Federal Violence Against Women Act, in addition to going back to Congress, another strategy might be to look for remedies at the state level.
Well, I guess I wondered whether you think that, suppose they uphold it,
Okay.
whether that would nonetheless be a good strategy to raise the political visibility of that issue, to make it a remedy that you could have in Durham, let's say, instead of driving to Greensboro to, you know, have a suit like that. What do you
Well,
think
you
about trying to normalize it
Mhm.
as part of state law?
The Violence Against Women Act civil rights remedy confers jurisdiction on both state and federal courts. Concurrent jurisdiction. So you just did have a case which Professor Schrager was nice enough to email me about earlier this week in Orange County, in which a lawyer won $2.75 million on behalf of a young girl who was sexually abused by a neighbor. That was a Violence Against Women Act claim brought in state court. And what I'm finding as I look at the cases is that many of these cases are being brought by personal injury attorneys and domestic relations lawyers. That's, you know, they're the ones who are accustomed to taking cases of people who are being beaten up and raped.
Right.
They are very comfortable in the state courts in their
Right.
given states. They don't know that much about federal procedure. They may not even be admitted in the federal court in their jurisdiction. They'd have to go get admitted or pro vice or something. So a lot of them are bringing the claims in state court. And we're getting some nice decisions out of the state courts. The case that was just resulted in a $2.75 million verdict, the same case earlier had resulted in a finding by the trial judge upholding the constitutionality of VAWA, and specifically not following the Fourth Circuit's opinion in Brancala, even though it's a North Carolina case, because as the trial judge pointed out, we're a state court. We answer to the U.S. Supreme Court, but we don't have to answer to the Fourth Circuit. So I admired the trial judge's independence in that.
We don't have any representation on the Fourth Circuit. So.
Right.
Okay, so that's right.
But you know, I think the point of trouble damages and attorney's fees in the parallel context of RICO, that's turned out to be a tremendously attractive provision for the private bar once they figure out how to do it, right? And brings in people who don't necessarily have some big ideological agenda, but understand that, you know, if you file it as a tort action, you get one consequence, and if you file it as the treble damage plus attorney's fees or whatever, whatever is encompassed.
Mhm.
So you put in these additional incentives,
Yes.
and the private bar, as I say, once it figures out,
Right.
does tend to respond to that.
Right, ATLA, which, for those of you not familiar with it, is the organization that represents the personal injury bar, primarily plaintiffs' personal injury bar, has run a number of articles on the Violence Against Women Act, and I'm seeing a lot of personal injury lawyers picking up on that. And I also teach family law, and we're starting to see Violence Against Women Act counts in a number of divorce actions where there has been
Right.
abuse.
Now, could I ask one follow-up question? I may be the only person in the room who doesn't know this. Does the 14th Amendment, is the 14th Amendment link necessary to create the jurisdiction in state courts under federal law? Is that the conceptual underpinning?
No, it's concurrent jurisdiction in state and federal courts, which
Right, but
is
it's
fairly
created
common.
under the federal act.
Well, you're creating a federal cause of action.
Right, and you have to have jurisdiction over that, so that's gonna fall, the state actions will fall if Brancala falls?
If the statute is declared unconstitutional, no one can bring a claim under, if the provision is
Under
declared
it.
unconstitutional, no one can bring a claim under it in state or federal court.
Right,
Because it was Congress. then.
right,
Yeah,
exactly.
it's a federal.
I just wanted to make sure that there
right of
wasn't
action.
some other basis for that, yes.
No. And people, these actions are also assaults, they're also,
Right.
they're actionable under state tort law, but you would lose the federal civil rights hook. Yes?
Can you discuss Congress's authority under Section 5 of the 14th Amendment to allow private actions as opposed to only state actions?
Yeah, it's interesting. I had a very enjoyable conversation about this morning with Professor Gerhardt's constitutional law class. It is a somewhat open question whether, under Section 5, Congress can legislate against purely private action. The Supreme Court has not spoken definitively on that issue in recent years. There are two cases from the 1960s and 70s that suggest that Congress can create a remedy directed at private actors in order to respond to some kind of action that is discriminatory and violates Section 1 of the 14th Amendment, that is to say, state action. Unfortunately, those cases don't squarely hold that creating action against private actors is permitted, they merely suggest it. So the issue is to some extent an open question, and the court may answer it for us, rightly or wrongly, or to good or to ill, in United States versus Morrison. But let me share with you some arguments that I think support a broader view of Congress's power here. Obviously, Section 1 of the 14th Amendment requires a showing of state action. I mean, it's a bar on state activity that denies, for example, equal protection of the laws. But Section 5 gives Congress the power to enact appropriate legislation to enforce that. And in recent cases, such as City of Bernie, Florida Prepaid, and Kimmel, the Supreme Court has said quite clearly that Congress's powers under Section 5 go beyond what Section 1 would permit. So, for example, Section 5 permits Congress to prohibit activities designed in order to remedy or prevent Section 1 violations. So Congress can go further than Section 1 when it legislates under Section 5. What we don't know is how much further, and whether that includes legislation directed at private actors. I also think that we need to be aware that even so-called private actors, some guy who beats up his wife or somebody who rapes a woman, do in some ways have significant links to state actors. We know that as a result of gender bias studies that have been done in many states throughout the country, we know that states are routinely treating violent crimes against women less seriously than other kinds of crimes. The stories are legion of judges poo-pooing domestic violence complaints, and then the woman unfortunately goes home and gets murdered. Judges trivializing or mocking rape victims, prosecutors who refuse as a routine matter to bring acquaintance rape cases because they don't think it's real rape. All of those kinds of state action, I think, contribute to the high rate of domestic violence and rape in our country. Men get the message that it's okay to do these things. So these nominally private actors are in fact, in important ways, acting in concert with the state actors. And Cass Sunstein, who I mentioned earlier, testified on this legislation, argued that interaction between the state actors and the private actors is sufficient to bring the private actors' activities under the heading of state action. You know, there's a case, United States versus Guest, where some white supremacists, basically Ku Klux Klan members, were doing horrible things to African Americans in their community, including, among other things, making false reports to the police that led the African Americans to then get arrested. And the United States Supreme Court held that that interaction between the private people making the phone call to the police and then the police going ahead and performing the arrest sufficed to make the action of the private individuals state action for purposes of federal civil rights law. And I think we have an analogy here. Yes?
Have any men brought VAWA claims?
Yes, there have been VAWA claims brought by men. It is a gender-neutral statute. It's not limited to women, although the title has the word women in it. Any act of violence motivated by gender that fits the definition can be brought. There was a case brought by a man who claimed that he was sexually abused by a clergyman, by a male clergyman. He actually had his case dismissed because the court found that the level of violence that he alleged was too low to meet the definition of crime of violence under the statute. So the court never reached the issue of whether it was gender motivated. But I think that we will see, if the provision survives, I think we will see cases brought by men. Interestingly, one of the first prosecutions under the criminal provision of the Violence Against Women Act, which makes it a crime to cross state lines to commit domestic violence or to violate an order of protection, one of the first prosecutions and convictions was against a woman who crossed state lines from New Jersey to New York to murder her husband. And she, interestingly, submitted an amicus curiae brief in this case from her prison cell.
On which side?
Opposed to legislation. So I think we will see, and I think that this, actually the civil rights provision, I think is very well suited to cases of gay bashing. I think that somebody who is assaulted or attacked because they're not acting the way we want a man to act or the way we expect a woman to act is being attacked because of their gender. After all, if they were of the other gender and acted that way, apparently the assailant would have thought that that was just fine. So I would hope that we could see, if the statute is upheld, more and more cases being brought in a wider variety of factual contexts. I thought that there would have been a good claim under VAWA in the case of Abner Louima in New York City, where the police officer sexually assaulted him with a nightstick. I thought that that was a pretty clear instance, and there was a whole overlay where the police officer thought that he was gay, and there was a whole overlay of gender and sexuality that I thought would have made an interesting VAWA claim. Yes?
Justice O'Connor's comment was interesting because we do have such federalization of child support law already since the mid-'80s.
Sure.
Does she know that, or?
I am very interested in the way that the federal courts look at the issue of the presence of family law in federal court. There is a myth that family law doesn't belong in federal court, it's never been there, it shouldn't be there. At the same time, we know that in addition to all this child support legislation, as you mentioned, we have the Defense of Marriage Act, we have a slew of federal constitutional cases dealing with everything from alimony, illegitimacy, paternity, child support, Stanton versus Stanton, I mean, you name it. So it is there, they just don't think it's there and they don't want it there. Judith Resnick has written an interesting piece on this about this blind spot.
The child support is an interesting analogy because, of course, child support doesn't show up in federal courts. It's a federal act that makes states do certain things, which is one way that Congress could go about repairing any constitutional defects that are found in existing VAWA. They could order, they'd have to find some latch for it. In the case of child support, it's federal monies in connection with other programs, but it would be an interesting way to go to order states to have something equivalent.
Yes, absolutely. In fact, this morning in the constitutional law class, and I see some familiar faces here from that group, I asked the students to help me conceive of solutions, fixes for this statute if it's struck down, and one possibility would be a spending clause hook where the states are given money on the condition that they clean up their act in the way that they treat victims of violence based on gender. We fear, however, that I've already been discussing these issues with some other folks in this field, and there's some fear that the domestic violence grassroots groups might oppose that they don't want to lose their money, they don't want to lose their grants because the state got their funding cut off because they didn't do the things that Congress told them to do.
Right.
So it could be a political.
One of the things behind my earlier question about the feasibility of reenacting a different version of the statute is that to the extent that in 1990 it could be shown that there was a lot of inactivity and a lot of discrimination in local and state enforcement, has that been cleared up enough that we could say there isn't this thing, that Congress couldn't actually operate under that factual?
Interesting question, whether we could still put together such a dramatic record.
Mm-hmm.
I don't know. I mean, ironically, one of the reasons that things look better at the
Right.
state level is because of the Violence Against Women Act, including the civil rights provision. Now, the civil rights provision doesn't in itself tell the states what to do, but it's part of this broader legislative scheme, and it is, I think, an important message to states about the importance of these issues. And one state official testified before Congress that the presence of the civil rights provision would have the impact of telling state officials that this is something you need to think about. So I obviously don't agree with the Fourth Circuit, which said that the civil rights provision can't possibly be congruent and proportional with the goal of getting states to stop discriminating against women, because after all, it's a cause of action against individuals, not against states. I don't agree with that. I think it's part of a broader scheme that's designed actually to get states to improve their practices.
Thinking about the Commerce Clause basis, I wonder what your own personal sense is of whether other forms of violent crime also affect commerce, and if you had been put in charge of a lobbying group to try to collect statistics and sort of create that record, do you think you could make a record that would be equally strong, or would the violence against women one somehow be distinctive? So where does this take us?
That's a great question. Now, in United States versus Lopez, the United States government tried to defend the Gun-Free School Zones Act by saying, oh, crime is really bad for the economy. Crime, the cost of crime, really bad for interstate commerce. And U.S. Supreme Court wasn't buying it.
Right.
Said, you could say that about any number of
Right.
things, and we can't throw open the floodgates and let Congress legislate on anything it wants. I think that gender-motivated violence is very different, because not only does it keep women out of the workforce and force them onto welfare and keep them in poverty, but it does that in a way that's discriminatory. Okay, it's not just the same as, if my car gets stolen tomorrow, or theft, or any other number of just generic crimes. It is a source of discriminatory exclusion from participation in the economy, and I think that makes it analogous to Title II of the Civil Rights Act as upheld in Katzenbach v. McClung and in Heart of Atlanta and Motel. Now, I will say, though, that the argument I've just advanced, which tries to use the discrimination issue to prop up the Commerce Clause argument, is one that at the oral argument in January, the Supreme Court did not seem receptive. In fact, they didn't seem to get it when both the Solicitor General and Julie Goldscheid, who represented Christy Barkala on behalf of Now Legal Defense Fund, tried to make that argument to distinguish violence against women from other just generic kinds of crime. In each instance, one or more justices of the court said, well, but now you're changing the subject to the 14th Amendment.
Right.
I was asking you, Counselor, about commerce, and that was really a very scary moment, because the justices did not see that what the lawyers were trying to do was to show that even within the commerce analysis, there is a special priority and a special recognition of impact on interstate commerce in the form of discriminatory exclusion of a disadvantaged group from participating in the economy. So I don't know that they'll get that, and yet I think it's a very strong and compelling argument. I mean, one of the things we're increasingly seeing empirically as we go through this whole welfare reform process is that one of the reasons that women have a lot of trouble achieving economic self-sufficiency is that when they try to go to school or into job training or get a job, their batterer makes it impossible for them to proceed. He wants her to be dependent. Economic independence is anathema to somebody who wants to exercise power and control. So he will destroy her books. He'll beat her up before the big job interview so she's too smashed up to go. He'll harass her and stalk her in her place of work until her boss fires her or she needs to quit. And there's been new legislation introduced in Congress, sort of building on the Violence Against Women Act, to try to prevent employers from discriminating against female or any employees on the basis of the fact that they're being victimized by domestic violence. They need job protection for that, which they don't currently enjoy. So, in short, I think it's a tough argument, but yet I think a very important one. And I'm not sure whether the Supreme Court even knows that that argument's being made, much less whether they're going to accept it. Yes?
I'm curious a little bit about how the federal judges' concerns have played out. Whether, I mean, obviously, the courts have not been so overwhelmed by VAWA claims as to be, completely clogged and ineffective. But I'm wondering, if any of their concerns, have materialized.
Yeah, well, one concern was that the federal courts be overwhelmed, and that's the big issue now for the federal judiciary. They just don't want any more anything. I mean, whenever something comes down the pike now, their response is, we don't want it. But especially something like this, which is, tied to women's issues and to domestic issues, they're not interested. But interestingly, their concern about specifically not wanting family issues in federal court has cropped up in the case law. The Fourth Circuit opinion in Bracala, as I said, emphasizes over and over, well, gee, this law threatens to bring domestic issues into federal court, and if we uphold this law, next thing you know, Congress is going to pass a comprehensive divorce statute, very similar to Justice O'Connor's line of questions at the court. So it is cropping up, and what's really scary is that it crops up even in cases that are favorable on the issue of constitutionality of the civil rights provision. There was a case, Seaton versus Seaton, in Tennessee, I think, in which the federal district court judge upheld the civil rights provision against a constitutional challenge, but then just added as a little editorial remark, I have to say that I'm really disturbed that Congress passed this law which is going to bring family law matters into federal court and is going to give women going through divorce a bargaining chip that they can use for tactical advantage rather than for actually seeking justice. Now that was so gratuitous to have that crop up in an opinion that otherwise was favorable to the cause of action suggests to me that the judiciary's resistance to this is very, very deep-seated.
Well, and very gendered.
Yes, the whole thing
it's
is
women seeking, the fear of women seeking revenge.
Yes.
Is pretty powerful.
Yes.
Yeah, it actually goes to something I wanted to ask you about. When I was working on this bill, one of the things that depressed me the most was the judges' stand, because I really thought it was unseemly and shabby, and that they were behaving, well, just like politicians. They were making the most outlandish arguments. Always worst-case scenarios were presented as the inevitable result of the act. It reminded me of the way people debated the Equal Rights Amendment, only then you actually had politicians standing up in Congress making arguments like the Equal Rights Amendment will compel us to have unisex laboratories
Right.
in public places and so on, which was fine. I didn't like those arguments, but I thought the appropriate people were making them. When Rehnquist and the other judges began making these arguments, I thought there had to be some gender animation in addition to, their sort of traditional siren song about needing to give backbone to politicians so they wouldn't just add new causes of action and overburden the courts.
Right.
I think that's a reasonable claim for judges to make when they're asked what the impact of more legislation is going to be on my workload and the quality of my decisions. But when they begin opposing particular pieces of legislation, singling out bills and doing it in such an outlandish way, I thought it was kind of really a low moment for the federal bench.
Well, I agree with you 120%, and just to, join in and second your sentiment, the state judges who speak through an umbrella organization known as the Council of Chief Justices said, this bill's a bad idea for a million reasons. One is it would override the marital rape exemption in rape law, which, permits husbands to rape their wives. Now, that's a reason not to pass it. I was wondering, is this 1990 or 1890? I thought that was frankly embarrassment to them. Interestingly, Michael Rothman, arguing on behalf of Antonio Morrison in the Supreme Court, made the same argument, that it is a state prerogative to determine whether to criminalize marital rape, whether to permit spouses or children, whether to permit spouses to sue each other in tort, or children to sue parents in tort, because of course we had common law immunities for those things that still exist in some states, and the federal government. should not step in. I also agree with you that this has to have been animated in part by gender bias, but I think filtered through a couple of intermediate steps. I've just written an article, going to be published this month in Ohio State Law Journal, in which I argue that the judges were motivated in large part by gender-specific notions of privacy. Their desire not to intervene in the domestic sphere ties back to a whole 19th century notion about the domestic sphere as a female realm in which the law does not intervene. It's a realm governed by emotion and sentiment rather than by law and money. And I really think that there are traces of that whole ideology in the response of the judges to this legislation. I think that that's very scary because they're operating on antiquated notions that are so subsumed under layers of accepted cultural practice that they don't even know how sexist they are. Because a lot of the arguments being made are arguments about privacy without a recognition that those arguments are intrinsically gendered. And you see that in the Brancala decision. Not only, I look at it in this article, not only in the judges lobbying on the bill, but also in the Fourth Circuit's en banc decision in Brancala, which uses the word private about 15 times and constantly harping on this idea that federal courts shouldn't go into this sacrosanct domestic sphere, which was the same argument that used to be used for not allowing state courts either to enforce any kind of judicial or any kind of legal redress for domestic violence. And the states have come quite a long way and recognize now that these types of injuries are actionable, but the federal courts are still adhering to those traditional notions. Yes?
Based on those comments, it would seem to me that it would be not unlikely but unusual for a court to find in a domestic violence situation that there was actually gender animus. I mean, if we're saying that courts are resistant to the notion that this is other than a private sphere, it would seem that, however, a family's divvy up responsibilities is not the place for the court to decide that these issues for the court.
You know, it's interesting. When this bill was passed, when it was pending, when it had just been passed, I anticipated that we would have a lot of resistance on the issue of gender motivation, and strangely enough, that hasn't happened. And my colleagues and I can't figure out why, except maybe all of the controversy has been displaced onto the constitutionality issue. Maybe if it's upheld, we will see this kind of thing. But I will only tell you that in the, 25 or 35, probably closer to 35, judicial decisions on point, judges have had no trouble finding the presence of gender motivation. In Christy Brancala's case, the very conservative trial court and the very conservative Fourth Circuit said, oh, this is clearly gender motivated. He used some very foul gender-specific language, and it was a gang rape, and the trial judge had this weird idea that gang rapes are somehow more gender discriminatory than individual rapes. I don't know where that was coming from. But the judges seem very comfortable with finding gender motivation. Take, for example, the Ziegler versus Ziegler case from Washington State. A man beat up on a regular basis his wife and his daughter. And the judge said, well, obviously he's got a thing against women. Another case involving domestic violence where the guy beat up his girlfriend saying, I don't want you to see any other men. The court said, well, that's gender motivation, this idea that she's his property and she can't see other men. Now, I was surprised. I mean, these are not sort of young, hip guys who majored in women's studies. I've been surprised that they have been that willing to find gender motivation. So it's an interesting anomaly, I guess.
Are those cases where the judge was the trier of fact, too?
Yeah, but some of them are coming up, a lot of them are coming up on motions to dismiss and motions for summary judgment where the judges, there has not been a full-fledged trial.
Mm-hmm.
The question is, has there been an allegation sufficient
Right.
to make out, if proven, sufficient to make out gender motivation?
There have been any jury trials?
Well, there was just this one in Orange County, North Carolina. There have been a number. There's even been an appeal to the Ninth Circuit in a rape case, and this ties back to your gender motivation question. A rape case did not raise a constitutional issue at all. It was just a VAWA trial on a rape matter. And the Ninth Circuit found that virtually every rape is gender motivated per se, which I found really intriguing because, as Professor Schrager probably remembers, there was an early version of the VAWA civil rights remedy that said there will be a rebuttable presumption that any sexual assault is gender motivated, and any other kind of an attack you have to go ahead and prove that it was gender motivated. That was dropped. It was politically untenable. And now you have the Ninth Circuit basically adopting that standard. Very interesting, just within the past month. Schenck versus Hartford or something is the name of that case. Should I wrap it up?
If there are no other questions, we can conclude.
Yeah.
Okay, thank you.
Thank you very much.